Good evening, everyone, and welcome back to the official channel of LegalEdge. Now, before we start with our today's monthly roundup, just do give me a tech check. Just let me know in the chat box whether I'm audible or not. Audible and visible too. Good evening, everyone. Good evening, good evening, good evening. I'm audible, guys, and visible also. चलो ऑल राइट सो लेट्स स्टार्ट विद आवर सेशन। अब ये चीज कई बार पहले भी आप लोगों के साथ डिस्कस हो चुकी है, ठीक है, एंड इट्स काइंड ऑफ अ क्लीशे फॉर द पर्पसेस ऑफ लीगल रीजनिंग नाउ कि भाई करंट लीगल नॉलेज या करंट लीगल अफेयर्स इज समथिंग व्हिच इज ऑफ पैरामाउंट इंपॉर्टेंस फॉर योर क्लैट पेपर। ठीक है, क्लैट के आप 2024 के बाद के जितने भी पेपर्स को देखोगे सब में आपको बहुत ही एक्स्ट्रा ऑर्डिनरी वेटेज देखने के लिए मिलेगा आपके करंट लीगल नॉलेज का, and therefore that is something which is important which you have to prepare throughout the year. तो मंथली राउंडअप्स इज समथिंग जिसको लेकर अभी हम कंटिन्यू कर रहे हैं, फिर स्लोली एंड स्टडीली हम वीकली राउंडअप्स की तरफ भी मूव करना स्टार्ट कर जाएंगे, ठीक है, एज एंड व्हेन द टाइम परमिट्स एंड द नीड अराइजेस। बट करेंटली विल बी हैविंग द राउंडअप ऑफ द मंथ ऑफ जनवरी। अब जनवरी के मंथ की अगर हम बात करें ना तो देयर आर सर्टेन नंबर ऑफ इंपॉर्टेंट टॉपिक्स फ्रॉम द फील्ड ऑफ लेजिस्लेशन, फ्रॉम द फील्ड ऑफ एग्जीक्यूटिव ऑर्डर्स or guidelines of the government, and along with that judgments of the Supreme Court and the High Court. तो जनवरी के अगर हम इंपॉर्टेंट टॉपिक्स की बात करें, so the first important topic is about the pending criminal cases and passport rights. That is, अगर आपके अगेंस्ट कोई क्रिमिनल केस पेंडिंग है उस पॉइंट ऑफ टाइम पे कैन यू रिन्यू योर पासपोर्ट और नॉट, इसको लेकर सुप्रीम कोर्ट ने जनवरी में एक इंपॉर्टेंट गाइडलाइन इशू करी, एक जजमेंट दिया। दैट इज फर्स्ट इंपॉर्टेंट टॉपिक फ्रॉम द मंथ ऑफ जनवरी। द सेकंड इंपॉर्टेंट टॉपिक इज अ वेरी रीसेंट वन wherein the Supreme Court recognized that menstrual hygiene is something which is part of Article 21 of the Constitution of India. ठीक है, जहां पे menstrual hygiene या menstrual hygiene से related actions को सुप्रीम कोर्ट ने आर्टिकल 21 का एक इंट्रिंसिक पार्ट माना, तो वो हमारा सेकंड इंपॉर्टेंट टॉपिक है, ठीक है। देन द थर्ड इंपॉर्टेंट टॉपिक फ्रॉम मंथ ऑफ जनवरी इज ऑस्ट्रेलिया सोशल मीडिया बैन फॉर चिल्ड्रन एंड इंडियाज पॉलिसी डिलेमा। ठीक है, ऑस्ट्रेलिया में 16 साल तक के बच्चों के ऊपर सोशल मीडिया को यूज करने के लिए वहां की गवर्नमेंट ने बैन लगाया, एंड हमारी कंट्री में स्टेट ऑफ आंध्र प्रदेश इज एक्चुअली लुकिंग इनटू दिस पर्टिकुलर मैटर दैट वेदर दे कैन आल्सो ऑप्ट फॉर अ सिमिलर काइंड ऑफ अ प्रोविजन, ठीक है, विद इन द स्टेट ऑफ आंध्रा और नॉट। तो वो हमारा थर्ड इंपॉर्टेंट टॉपिक है, ठीक है। द फोर्थ इंपॉर्टेंट टॉपिक एज ऑफ नाउ इज नॉट द डिस्टर्ब्ड एरियाज लॉज एंड प्रॉपर्टी राइट्स, ठीक है, क्योंकि ये थोड़ा एक डिटेल्ड टॉपिक हो जाएगा, तो इसके लिए हम अलग से कोई एक सेशन कंटिन्यू करके वहां पर इसको समझ लेंगे, जो कि डिस्टर्ब्ड एरिया वाला हमारा टॉपिक होगा, ठीक है। सो द नेक्स्ट टॉपिक विल बी अबाउट सेलिब्रिटी एंडोर्समेंट एंड कंज्यूमर लायबिलिटी। कंज्यूमर प्रोटेक्शन एक्ट 2019 के अंडर डेफिशिएंसी इन सर्विसेज के लिए क्या आप किसी ब्रांड एम्बेसडर को लाइबल कर सकते हो या नहीं कर सकते हो, इस पॉइंट ऑफ व्यू पे केरला हाईकोर्ट ने रिसेंटली एक वर्डिक्ट दिया। So that is the fourth topic जिसको आज हम डिस्कस करेंगे। The fifth important topic is जिसको लेकर रिसेंटली बहुत कंट्रोवर्सी भी हुई, which is about the UGC guidelines, है ना। वो चीज आप लोगों ने अपने न्यूज़पेपर में पढ़ी भी होगी कि 2026 में गवर्नमेंट एक गाइडलाइन लेकर आती है यूजीसी की इक्विटी गाइडलाइंस। तो वो पूरा का पूरा टॉपिक क्या था, गाइडलाइंस क्यों आई थी, गाइडलाइंस एग्जैक्टली थी क्या, और गाइडलाइंस को किन ग्राउंड्स पे सुप्रीम कोर्ट ने स्टे लगाया, ठीक है। दैट इज द फिफ्थ टॉपिक, आई एम सो सॉरी, which we'll be discussing, and another important topic from the month of January, ठीक है। जनवरी के अगर हम एक और इंपॉर्टेंट टॉपिक की अगर हम बात करें ना तो दैट इज अबाउट द इशू ऑफ उमर खालिद्स बेल मैटर, ठीक है। दिस पर्टिकुलर टॉपिक केम इन द वेरी बिगिनिंग ऑफ द मंथ ऑफ जनवरी। ये जनवरी की बहुत ही स्टार्टिंग के पॉइंट का टॉपिक था, एंड इसको लेकर हमने एक अलग से सेशन कंडक्ट किया हुआ है, इसलिए हम इस पर्टिकुलर टॉपिक को यहां पर कंटिन्यू नहीं कर रहे। शुड वी मेक नोट्स ऑफ दिस? यस बेटा, शॉर्ट हैंड नोट्स आप बनाते हुए चलना साथ में, ठीक है, दैट विल बी हेल्पफुल फॉर यू, ठीक है। दैट पर्टिकुलर टॉपिक ऑफ द सुप्रीम कोर्ट सजेशन टू इंट्रोड्यूस द रोमियो जूलियट क्लॉज, दैट इज अनदर समथिंग इंपॉर्टेंट टॉपिक जिसको लेकर आई हैव डिसाइडेड कि इन द मंथ ऑफ फेब आई विल बी कंडक्टिंग अ पर्टिकुलर सेशन ऑन द पॉक्सो एक्ट, ठीक है। पॉक्सो पे हम एक सेशन को कंडक्ट करेंगे, एंड उस पर्टिकुलर सेशन में विल बी डिस्कसिंग अबाउट दैट रोमियो जूलियट क्लॉज स्पेसिफिकली, ठीक है। चलो, सो लेट्स कम टू आवर फर्स्ट टॉपिक, एंड द फर्स्ट टॉपिक व्हिच वी हैव इज pending criminal cases and passports rights of the person. That is, the Supreme Court gave a decision regarding Article 21 and the right of the passport as well. तो देखो ये particular topic news में आया ही क्यों? So there was an individual, ठीक है? There is a person A, let's say. Now passport given to a person is actually valid for a period of 10 years. And after every 10 years, you are supposed to renew your passport. ठीक है, हर 10 साल के बाद आपको अपने पासपोर्ट को रिन्यू करवाना होता है. एंड पासपोर्ट इज समथिंग, ठीक है, पासपोर्ट इज समथिंग विच इज वेरी इंपॉर्टेंट फॉर फॉरेन ट्रैवल्स, राइट? And right to travel abroad has been declared as a part of Article 21 of the Constitution of India. Right to travel abroad is something which is part of Article 21 of the Constitution of India, which was declared so by the Supreme Court of India in the case of Maneka Gandhi in the year 1978. 1978 में सुप्रीम कोर्ट ने ये चीज डिक्लेयर कर दी थी दैट राइट टू ट्रैवल अब्रॉड इज समथिंग इट इज पार्ट ऑफ आर्टिकल 21 ऑफ द कॉन्स्टिट्यूशन ऑफ इंडिया. तो पॉइंट ये है कि जब भी एक पर्सन अगर मान लो पासपोर्ट रिन्यू करवाने जाता है और उसके ऊपर कुछ पेंडिंग क्रिमिनल केसेस हैं, उसके ऊपर अगर कुछ पेंडिंग क्रिमिनल केसेस हैं, दैट इज द पर्सन हैज नॉट बीन कन्विक्टेड येट, ठीक है, the trial is still going, so there are certain kind of accusation against a person that the person is involved in a particular crime. So pending criminal cases के situation में क्या authorities, can executive authorities deny to approve the renewal of the passport of an individual provided अगर वहां पर courts ने no objection certificate provide कर दिया है तो, ठीक है, कि अगर कोर्ट्स ने नो ऑब्जेक्शन सर्टिफिकेट दे दिया है तो क्या उसके बाद भी एग्जीक्यूटिव अथॉरिटीज, पासपोर्ट अथॉरिटीज क्या किसी पर्सन के पासपोर्ट के रिन्यूअल के ऊपर स्टे लगा सकते हैं, उसको पासपोर्ट रिन्यू करने से मना कर सकते हैं? दिस वाज द प्राइमरी इशू इन फ्रंट ऑफ द सुप्रीम कोर्ट ऑफ इंडिया इन दिस पर्टिकुलर सिचुएशन, जहां पर सुप्रीम कोर्ट ने अभी एक जजमेंट दिया दैट बिकॉज़ ट्रैवलिंग अब्रॉड, ठीक है, बिकॉज़ ट्रैवलिंग अब्रॉड इज समथिंग इट इज पार्ट ऑफ आर्टिकल 21 ऑफ द कॉन्स्टिट्यूशन ऑफ इंडिया. And therefore, once the courts have provided no objection certificate for the renewal of the passport of any particular person, pending criminal charges will not become a ground for denying the renewal of the passport of that particular person. Are we clear? Background मैंने भी आपको summary में समझा दिया. Summary clear है केस की भाई? That what exactly is the issue in this particular case? ठीक है? चलो, तो let's discuss why this particular case is important. So it clarifies whether pending criminal charges can bar passport issuance. ठीक है. Secondly, it balances the state's power vis-a-vis your individual liberty. Then this is something which is very much important. ठीक है. That passport is something which is a part of Article 21 of the Constitution of India, because Article 21 will include right to travel abroad. ठीक है, and this particular topic is important from the point of view of constitutional law, administrative law and fundamental rights jurisprudence as well. ठीक है, that's the primary relevance of this particular case, and the core legal question in front of the Supreme Court of India in this particular case was that can the passport authorities deny renewal of a passport solely because criminal proceedings are pending even when the courts have issued no objection orders. ठीक है, अगर courts ने no objection order issue कर दिया है तो उसके बाद भी क्या पासपोर्ट अथॉरिटीज वहां पे आपके रिन्यूअल को मना कर सकती है? दिस वाज द प्राइमरी क्वेश्चन इन फ्रंट ऑफ द सुप्रीम कोर्ट ऑफ इंडिया. तो अब इस केस के फैक्ट्स एग्जैक्टली क्या थे? व्हाट वर द फैक्ट्स? सो देयर वाज एन इंडिविजुअल नेम्ड महेश कुमार अग्रवाल हु वाज इशूड पासपोर्ट इन द ईयर 2013 विद 10 इयर्स वैलिडिटी. ठीक है, महेश कुमार अग्रवाल नाम का एक इंसान था, उसको पासपोर्ट इशू किया गया था 2013 में, 10 साल की उसकी वैलिडिटी थी पासपोर्ट की. So the passport was supposed to expire by the year 2023. ठीक है, passport was about to expire in the year 2023. Now, what happened in this particular case was that during the validity of the passport, This person was charged as an accused in an NIA case. NIA basically stands for National Investigation Agency. So this particular person, okay, Mahesh Kumar Agrawal, was charged as an accused in an NIA case for the offense of extortion and funding banned organization, and he was convicted in one of the CBI coal block case. ठीक है, जहां पर उस कोल ब्लॉक स्कैम केस में उनको 4 साल का सेंटेंस दिया गया, बट द सेंटेंस वाज सस्पेंडेड बाय द दिल्ली हाई कोर्ट पेंडिंग अपील. ठीक है, appeal was pending in the Delhi High Court, and the particular sentence was actually suspended by the Delhi High Court during that particular duration. Now, the courts in these two cases directed the surrender of the passport and restricted the foreign travel without permission. ठीक है, इन दोनों ही केसेस में कोर्ट ने महेश कुमार अग्रवाल से क्या कहा, that you have to surrender your passport and you will not travel without the permission of the court. आप फॉरेन ट्रैवल नहीं करेंगे without the permission of the court. ठीक है, these conditions were attached on. सब्सिक्वेंटली क्या होता है कि पासपोर्ट वाज नियरिंग एक्सपायरी. ठीक है, पासपोर्ट अब एक्सपायर होने वाला था, 2023 तक के लिए उनका पासपोर्ट वैलिड था. नाउ बिकॉज द पासपोर्ट वाज नियरिंग एक्सपायरी, सो ही कोर्ट एंड द दिल्ली कोर्ट फॉर द पर्पसेस ऑफ रिन्यूअल ऑफ द पासपोर्ट. ठीक है, क्योंकि पासपोर्ट कोर्ट ने डिपॉजिट करके रख लिया था अपने पास, दैट यू आर नॉट सपोज टू डू फॉरेन ट्रैवल. ठीक है, देन इन दैट पर्टिकुलर सिचुएशन yeah, am I audible, guys? Am I audible? Chal. So, because the passport was confiscated by the court, okay, and the person was stopped from taking any kind of foreign travel, subsequently, an IA court, which was looking into the case, okay, Ranchi case court ne granted no objection for renewal, okay, and the passport was released by the court only for the purposes of renewal. Renewal के purposes के लिए NIA court ने passport को release भी कर दिया, but the court prohibited the person to travel abroad without the prior permission of the court. कि कोर्ट की प्रायर परमिशन के बिना, ठीक है, कोर्ट की प्रायर परमिशन के बिना आप वहां पर ट्रैवल नहीं करोगे, एंड द पासपोर्ट वाज सपोज्ड टू बी रीडिपॉजिटेड आफ्टर द रिन्यूअल एज वेल. ठीक है, कि एक बार जैसे ही रिन्यूअल हो गया, देन द पर्सन वाज सपोज्ड टू डिपॉजिट द पासपोर्ट एज वेल. दिल्ली हाई कोर्ट में भी क्योंकि इनके ऊपर केस चल रहा था, सो दिल्ली हाई कोर्ट आल्सो प्रोवाइडेड दैट देयर इज नो लीगल बार टू रिन्यूअल एंड ही कैन कंटिन्यू ट्रैवल, बट द कोर्ट कंटिन्यूड द ट्रैवल रिस्ट्रिक्शन इन दैट केस आल्सो. कोर्ट ने कहा that you can renew your passport, there is no objection in that, but you cannot travel without the permission of the court. तो दोनों ही कोर्ट्स ने ये चीज याद रखना that उन्होंने, ठीक है, both the courts did what? Just give me a second, भाई, just give me a second, बच्चा. दोनों ही कोर्ट्स ने क्या करा? बोथ द कोर्ट्स प्रोवाइडेड नो ऑब्जेक्शन फॉर द रिन्यूअल, बट द कोर्ट्स इम्पोज्ड ट्रैवल रिस्ट्रिक्शन एज वेल. ठीक है, दोनों ही कोर्ट्स ने नो ऑब्जेक्शन प्रोवाइड कर दिया, बट द कोर्ट्स प्रोवाइडेड ट्रैवल रिस्ट्रिक्शन एज वेल दैट यू विल नॉट ट्रैवल अब्रॉड विदाउट द परमिशन ऑफ द कोर्ट. अब सब्सिक्वेंटली जब इस पर्सन ने पासपोर्ट अथॉरिटीज को अप्रोच करा फॉर द रिन्यूअल ऑफ द पासपोर्ट, ठीक है, व्हेन दिस पर्सन अप्रोच द ट्रैवल अथॉरिटीज और पासपोर्ट अथॉरिटीज फॉर द पासपोर्ट्स अप्रूवल रिन्यूअल, द रीजनल पासपोर्ट ऑफिस रिफ्यूज टू रिन्यू द पासपोर्ट. ठीक है, रीजनल पासपोर्ट ऑफिस ने रिन्यू करने से मना कर दिया एंड दे रिलाइड ऑन सेक्शन 6 क्लॉज 2 सब क्लॉज F ऑफ द पासपोर्ट्स एक्ट एंड जो आर्ग्यूमेंट प्राइमरली वहां पर अथॉरिटी ने दिए, दे स्टेटेड दैट बिकॉज क्रिमिनल प्रोसीडिंग्स आर पेंडिंग अगेंस्ट द कोर्ट, ठीक है, क्योंकि आपके अगेंस्ट क्रिमिनल प्रोसीडिंग्स पेंडिंग है, देयरफॉर योर पासपोर्ट विल नॉट बी अप्रूव्ड। एंड सेकेंडली दे स्टेटेड कि एक एक्सेप्शन अलाउ किया जाता है जहां पर पेंडिंग क्रिमिनल केसेस में भी आपका पासपोर्ट तो रिन्यू हो सकता है, प्रोवाइडेड इफ द कोर्ट्स परमिट द फॉरेन ट्रैवल, ठीक है, कि अगर कोर्ट्स फॉरेन ट्रैवल परमिट कर दे, उस सिचुएशन में पेंडिंग क्रिमिनल केसेस होने के बाद भी आपके पासपोर्ट्स को रिन्यू किया जा सकता है। आर वी क्लियर टू दिस पॉइंट? यहां तक क्लियर है? समझ में आया? तो पासपोर्ट अथॉरिटीज ने क्या कहा कि भाई आपका पासपोर्ट रिन्यू नहीं हो सकता क्योंकि पेंडिंग क्रिमिनल केसेस है, एंड देयर इज वन एक्सेप्शन दैट इफ द कोर्ट परमिट्स फॉरेन ट्रैवल, अगर कोर्ट फॉरेन ट्रैवल परमिट कर दे, सिर्फ तब आपके पासपोर्ट को रिन्यू किया जा सकता है, इवन व्हेन यू हैव पेंडिंग केसेस। इस ग्राउंड पे पासपोर्ट अथॉरिटीज ने रिन्यू करने से मना कर दिया। एंड रिमेंबर दैट, ठीक है, इस केस में कोर्ट ने ट्रैवल रिस्ट्रिक्शन इंपोज करके रखा हुआ था दैट यू विल नॉट ट्रैवल अब्रॉड, ठीक। सो कलकत्ता हाईकोर्ट में जब महेश कुमार अग्रवाल ने केस फाइल किया रिगार्डिंग द डिसीजन ऑफ द पासपोर्ट अथॉरिटीज, द कलकत्ता हाईकोर्ट आल्सो अपहेल्ड द रिफ्यूजल, ठीक है, कलकत्ता हाईकोर्ट ने भी उनके रिफ्यूजल को अपहोल्ड कर दिया। अब यहां पर जो रेलेवेंट प्रोविजंस थे जो आपको पैसेजेस में दिख सकते हैं, ठीक है, उसको डेप्थ में देखने की जरूरत नहीं है, ठीक है, यू डोंट हैव टू लुक इनटू दीस प्रोविजंस इन डेप्थ, बट जस्ट हैव एन आइडिया कि ये सारे प्रोविजंस इस केस में इन्वॉल्व थे, लाइक सेक्शन 5 ऑफ द एक्ट व्हिच टॉक्स अबाउट इशुएंस और रिफ्यूजल बाय रिटन ऑर्डर दैट द पासपोर्ट अथॉरिटी कैन आइदर इशू और कैन रिफ्यूज टू issue the passport but through a written order. Then section 6(2)(f) which talks about refusal if criminal proceedings are pending, but there is an exception provided that if foreign travel is permitted. Then section 6(2)(e) which talks about post conviction bar, that if a person is convicted of a crime and given a sentence of more than 2 years, then the person can be refused to have a passport in that situation. Then section 7 and 8 basically talk about short-term passports and extension. Section 10 talks about power to impound or revoke the passport. This particular provision was invoked by the courts in the Luthra brothers case recently. Remember, in the month of December in Goa, a nightclub caught fire in which certain amount of persons died as well. In that situation, the government planned to impound or revoke the passport given to Luthra brothers. So, whenever there is a revocation or impounding of a passport, that is something which is done as per section 10 of the act. ठीक है? अब यहां पर गवर्नमेंट ने गाइडलाइंस भी इशू करके रखी थी, ठीक है? The central government had issued a certain guidelines as well that if the courts think fit, ठीक है? If the courts think fit, then they can allow for the renewal of the passport of an individual. ठीक है, कि कोर्ट्स के अप्रूवल के बेसिस पे आप एक पर्सन के पासपोर्ट को रिन्यू भी कर सकते हो। So this was issued under section 22 of the act and it creates an exemption from section 6(2)(f. वो जो 6(2)(f) में चीज प्रोवाइडेड है ना, that pending criminal proceedings passport will not be renewed, उस पर्टिकुलर चीज से exemption प्रोवाइड कर सकते हैं कोर्ट्स, ठीक है। And the condition which is required over there is that the courts must apply its mind and the applicant must give undertaking to appear before the court whenever necessary. ठीक है, ये एक्सेप्शन भी गवर्नमेंट ने प्रोवाइड करके रखा हुआ था। तो बैकग्राउंड समझ में आ गया, प्रोविजन समझ में आ गए, ठीक है। कोर्ट ने एनओसी प्रोवाइड कर दी थी उन एग्जेम्पशंस वाली गाइडलाइंस के अंडर दैट यू कैन रिन्यू योर पासपोर्ट बट यू कैन नॉट ट्रैवल अब्रॉड। पासपोर्ट ऑफिस या पासपोर्ट अथॉरिटीज ने क्या किया, because there was no specific travel permission given by the court, therefore they refused to renew the passport of this individual. But then when the matter reached the Supreme Court of India, Supreme Court stated that, ठीक है, when section 6(2)(f), ठीक है, is given in the act, it is not creating an absolute bar, ठीक है, it's not creating an absolute bar because the guidelines of the government provide an exception, ठीक है। The guidelines of the governments provide an exception that if the courts think they can allow for the renewal of the passport of an individual, and once the exemption conditions are met, refusal is unjustified in that situation. ठीक है, clear? ठीक, तो because of the fact, just because of the fact that the courts have denied the travel permission, that will not become a ground to deny the renewal of a passport of an individual, provided the courts have provided no objection certificate. कोर्ट्स ने अगर नो ऑब्जेक्शन सर्टिफिकेट प्रोवाइड कर दिया तो फिर ट्रैवल अलाउ ना करना एक ग्राउंड नहीं बन जाएगा आपका, जिसके बेसिस पे आप सेक्शन 6(2)(f) को अप्लाई करके उस पर्सन के पासपोर्ट को रिन्यू करने का डिनायल प्रोवाइड करो वहां पर. ठीक है, ठीक. एंड द कोर्ट बेसिकली रिजेक्टेड द पासपोर्ट अथॉरिटीज आर्गुमेंट एज वेल because they provided that, or the court stated that no law requires the court to approve of a specific foreign trip. ऐसा कोई भी नहीं है. ठीक है, ऐसा कोई भी लॉ हमारी कंट्री में नहीं है जो ये कहे कि भाई हर स्पेसिफिक फॉरेन ट्रिप को आपको अप्रूव करना पड़ेगा. ठीक है, एंड पासपोर्ट अथॉरिटीज कैन नॉट ओवरराइड जुडिशियल सुपरविजन. ठीक है, एक बार कोर्ट्स ने अगर वहां पर अलाउ कर दिया देन पासपोर्ट अथॉरिटी जुडिशियल सुपरविजन को आपका एक तरीके से ओवरराइड नहीं कर सकती. ठीक है, आर वी क्लियर विद दिस पॉइंट? ठीक है, clear? So the primary legal principles which are established in this particular case included that pending criminal cases will not become an automatic ground for passport denial. ठीक है, किसी पर्सन के ऊपर क्रिमिनल केसेस पेंडिंग है वो अपने आप में ग्राउंड नहीं बन जाएगा जिसके बेसिस पर आप उसको पासपोर्ट डिनाई कर दो. द कोर्ट्स एनओसी विल प्रिवेल ओवर द पुलिस ऑब्जेक्शन. पुलिस अगर ऑब्जेक्ट कर भी रही है, ठीक है, तब भी कोर्ट का वहां पर एनओसी प्रोवाइड कर देना will prevail over the police objections. In that case, the passport authorities must act proportionately, and Article 21 of the Constitution has a substantive content beyond the procedure which is provided over there. ठीक है, क्योंकि right to travel abroad, ठीक, because right to travel abroad is part of Article 21 of the Constitution, then procedural necessity के ground पर आप उस चीज को violate नहीं कर सकते हो in a disproportionate manner. ठीक है, शॉर्ट हैंड कहानी लिखते हुए चलो बेटा. ठीक है, दोज हु आर एलई स्टूडेंट विल इवेंचुअली गेट द पीडीएफ एज वेल. ठीक है, जितने एलई स्टूडेंट्स हैं उन सबके पास पीडीएफ इवेंचुअली पहुंच जाएगी. अभी शॉर्ट हैंड नोट्स बनाते हुए चलो आप लोग साइड बाय साइड. ठीक है, चलो. सो लेट्स मूव टू द नेक्स्ट टॉपिक. द नेक्स्ट टॉपिक फ्रॉम मंथ ऑफ जनवरी इज अबाउट द राइट ऑफ मेंस्ट्रुअल हाइजीन. ठीक है, wherein the Supreme Court judgment provided for access, equality and education as well. Now why this particular thing came into news? तो हमारी कंट्री में एक एक्ट एग्जिस्ट करता है जिसको हम राइट टू एजुकेशन एक्ट कहते हैं. ठीक है, which provides for free and compulsory education to child between the age of 6 to 14 years. 6 साल से 14 साल तक के बच्चे को फ्री एंड कंपल्सरी एजुकेशन स्टेट प्रोवाइड करता है. फ्री एंड compulsory primary education is provided by the state. अब पॉइंट क्या था? पॉइंट क्या है कि भाई when it comes to the constraints that why a particular person or why a child will not go to the school. So one of the primary understanding which was developed earlier was that people generally tend to avoid school because of financial reasons. ठीक है, that people will tend to drop out from the school because of financial reason. That maybe they are not in a position to afford the fees of the school and therefore they are avoiding the education as well. But recently, or in the past 3-4 years, the courts realized that it is not only the finance which is becoming a reason for the dropout of a girl child from the school. ठीक है, ठीक, एक लड़की के स्कूल छोड़ने का कारण सिर्फ पैसे नहीं थे. There were multiple other reasons as well, and one such reason was menstrual hygiene management system missing from the school. ठीक है, that is menstrual hygiene management system missing from the school. ठीक, because there was no sensitization of the school environment, including the boys as well, and that was becoming one of the reasons that why the female students were increasingly dropping out from the school between that age group. And thus certain number of PILs are filed in the Supreme Court of India. And Supreme Court recently passed a continuing mandamus wherein they recognize that right of menstrual hygiene is something which is part of Article 21 of the Constitution of India as well. तो वहां पर menstrual hygiene को Article 21 के पार्ट की तरह recognize किया and certain guidelines were issued by the court as well. So we'll be discussing that now. So recently the Supreme Court bench, including Justice J.B. Pardiwala and Justice R. Mahadevan, okay, was dealing with the issue of lack of menstrual hygiene facilities in the school. Okay. It was a division bench. It was a division bench of the Supreme Court which was dealing with the issue of lack of menstrual facilities, hygiene facilities within the school. And the primary concern in this particular case was absenteeism and dropouts among girl students. This was the primary reason that why the case was filed in the Supreme Court. And the court issued a continuing mandamus to monitor the compliance. Okay? Do you understand what mandamus is? Mandamus पता है भाई सबको? देखो, there are certain writs, right, given in the Constitution of India. Constitutional law में आप writs के बारे में पढ़ते होगे, है ना? One such writ is writ of mandamus. Mandamus. And mandamus simply means we command. That whenever a particular public authority is not performing their duty or their act, okay, whenever the public authority is not performing their duty, okay, then the court orders them to fulfill their constitutional, legal or statutory duty. Okay, वहां पर जो कोर्ट का ऑर्डर होता है, that order is known as mandamus. Okay, now what is a continuing mandamus? Continuing mandamus. Now, see, whenever a mandamus will be issued by the court, the case will come to an end. Yes or no? है ना? Whenever will court pass a mandamus against the authority, court order pass कर देगा कि आपको ये करना है, and the case will come to an end. Continuing mandamus में क्या होता है कि where certain orders are given by the court and the courts want to, ठीक है, look into the compliance of the order as well, कि हमने आपको orders pass कर दिए, अब कोर्ट ये भी रिव्यू करेगा कि वो ऑर्डर फुलफिल हो रहा है प्रॉपर्ली या नहीं. ठीक है, उस सिचुएशन में द कोर्ट विल पास कंटिन्यूइंग मैंडेमस सो दैट द कोर्ट कैन कीप द केस ओपन फॉर द रिव्यू ऑफ द कंप्लायंस ऑफ द ऑर्डर ऑफ द कोर्ट एज वेल. ठीक है, कि कोर्ट के ऑर्डर को प्रॉपर्ली कंप्लाई किया जा रहा है या नहीं जा रहा, उसको रिव्यू करने के लिए कोर्ट कंटिन्यूइंग मैंडेमस पास करता है. ठीक है, आर वी क्लियर with the difference of mandamus and continuing mandamus? So in this particular case, the court issued a continuing mandamus to monitor the compliance of the case as well. ठीक है, अब ये केस था क्या, या ऑर्डर्स वहां पर पास क्या किए. ठीक है, so primary issue was the absence of menstrual facilities for the girl child in a particular school. So earlier menstruation was, or the menstrual facilities were viewed as a public health issue. उनको एक पब्लिक हेल्थ इशू माना जाता था. ठीक है, सर कैन मैंडेमस बी इशूड टू प्राइवेट एंटिटीज? नो बेटा सुजान, मैंडेमस इज समथिंग व्हिच कैन ओनली बी इशूड अगेंस्ट पब्लिक अथॉरिटी और एनीबॉडी हु इज परफॉर्मिंग अ पब्लिक ड्यूटी, नॉट प्राइवेट एंटिटीज. ठीक है, सो सपोजिटली इफ वी आर नॉट टेकिंग मंथली राउंड ऑफ सेशंस, then you cannot go to the court and ask the court to issue the writ of mandamus against us because we are a private entity. ठीक है, now earlier menstrual health facilities were considered as, ठीक है, a public health issue, but now court recognized it as a constitutional entitlement. ठीक है, अब कोर्ट ने इस चीज को, इस पर्टिकुलर इशू को आपका कॉन्स्टिट्यूशनल एंटाइटलमेंट की तरह recognize किया. And menstrual hygiene is something which is linked to dignity of the women, equality of the women, education and bodily autonomy as well. Because the primary question which was asked by the court or discussed by the court was that why should a biological process become a ground of stigmatization or dropouts from the school, right? So that was something which was being discussed in the court, and the court basically referred to or invoked Article 14 of the Constitution of India in this particular case. ठीक है, कोर्ट ने आर्टिकल 14 को इन्वोक किया. व्हाट इज आर्टिकल 14? आर्टिकल 14 बेसिकली टॉक्स अबाउट इक्वालिटी बिफोर लॉ. यस और नो? बट equality within the Constitution of India, is it referring to absolute equality? That notwithstanding anything, you will treat everyone similarly. क्या equality का मतलब absolute equality है क्या? कि irrespective of the fact of anything, you will treat everyone equally. ऐसा थोड़ी ना है. The Constitution of India wants to treat those equally who are similarly placed. Yes or no? And that is something which is known as substantive equality as well. है ना? So the court said that equality within the Constitution does not mean identical treatment, because identical treatment in itself will lead to a greater number of inequality within the system. भाई अब मुझे और सब लोगों को अगर बराबर से ट्रीट करना शुरू कर दोगे तो वो अपने आप में इनजस्टिस नहीं हो जाएगा. अब मैंने लॉ स्कूल पास कर लिया है, मैंने कॉन्स्टिट्यूशन लॉ पढ़ लिया है, मैं आप लोगों को मतलब मुझे और आपको एकदम बराबर से अगर सब लोग ट्रीट करेंगे तो is it equality? Is it justice? It is not. And therefore the court stated that equality in itself does not mean identical treatment, right? And the court basically applies substantive equality doctrine, which wants, जो कि equal protection of law में given है, that treat those individuals equally who are similarly placed. And therefore the court understood that the girls face unique biological realities as well, and lack of facilities within the institution converts biological realities into structural exclusion. है ना कि भाई अगर वहां पर प्रॉपर मेंस्ट्रुअल हाइजीन की फैसिलिटी नहीं होगी तो उस सिचुएशन में वो जो बायोलॉजिकल रियलिटी है ऑफ अ गर्ल चाइल्ड विल कन्वर्ट इटसेल्फ इनटू अ स्ट्रक्चरल एक्सक्लूजन. वो उनको अलग करने का एक रीजन बन जाता है, उनके खुद को अलग करने का एक रीजन बन जाता है. ठीक है. एंड दिस अनइक्वल कंडीशन वुड ऑब्वियसली रिक्वायर अनइक्वल सपोर्ट एज वेल. कि भाई अब वहां पर अगर सिचुएशन एक गर्ल चाइल्ड के लिए रिक्वायरमेंट, ठीक है, उसकी जरूरत अगर अलग है तो आपको वो अनइक्वल ट्रीटमेंट उसको देना पड़ेगा, वो एक स्पेशल सपोर्ट आपको उसको देना पड़ेगा. And then the court came to the point of Article 21 of the Constitution of India, wherein the court stated that right to life includes right to live with dignity, privacy, and bodily autonomy. And absence of menstrual health management facilities within the institution causes stigma, humiliation, and forced absenteeism. Yes or no? I know that as a matter of fact that many of us must have faced these kind of problems within the institution. Yes or no? है ना? तो कोर्ट ने वही कहा that the absence of menstrual hygiene management system or facilities, it causes a stigma, it causes humiliation, it causes forced absenteeism of the women child from the school. And therefore the court stated that these absence of facilities violates Article 21 of the Constitution of India. कि भाई ये उस बच्ची के आर्टिकल 21 ऑफ द कॉन्स्टिट्यूशन ऑफ इंडिया का वायलेशन है. Then the court went to the next stage or the next law which is involved over there, that is Right to Education Act of 2009. ठीक है. कोर्ट ने कहा Right to Education Act, every institution, be it a public school or a private school, everyone is required to follow this now. We'll look into the guidelines which are issued by the court as well. ठीक है. अभी हम वो गाइडलाइंस भी देखेंगे जो कोर्ट ने इशू करी थी. एवरी इंस्टीट्यूशन इज रिक्वायर्ड टू फॉलो दिस. ठीक है. फिर कोर्ट ने राइट टू एजुकेशन एक्ट को डिस्कस करना शुरू करा एंड कोर्ट ने कहा सेक्शन 3 ऑफ द एक्ट टॉक्स अबाउट फ्री एजुकेशन. ठीक है. बट फ्री एजुकेशन डज नॉट ओनली मीन फी वेवर. ठीक है. कि आपने फ्री एजुकेशन का नाम तो वैसा फीस नहीं मांग रहे. दैट इज नॉट द सोल पर्पस और द इंटेंट ऑफ द एक्ट. फ्री एजुकेशन वुड इंक्लूड रिमूवल ऑफ all kind of financial barriers, and the cost of sanitary napkins is a kind of a financial barrier which causes absenteeism and dropouts of the women or girl child from the school. ठीक है. कोर्ट ने कहा भाई फ्री मतलब फ्री एजुकेशन का मतलब फीस माफ कर दी है, उतना नहीं है. फ्री एजुकेशन will include removal of all kind of financial barriers, and even if the cost of sanitary napkins is becoming a kind of a financial barrier, then the state is responsible to remove that barrier from the girls' education as well. ठीक है. Clear? Now, the state in action makes education conditional and free sanitary napkins, ठीक है, free sanitary napkins are now considered as a statutory obligations. हाँ, तो Sujan, for that particular thing, what happens is when you talk about Right to Education Act, Right to Education Act is something that is applicable on private institutions as well. And when private institutions are working in the field of imparting education, okay, under the provisions of the Act, they are performing a kind of an act which is falling within the nature of a public duty. And because those private educational institution receive some kind of an aid or recognition from the state, therefore they are someone which can be included within this category. And secondly, you remember Article 142 of the Constitution of India? It gives the power to the Supreme Court to issue any kind of an order to do complete justice in any case. So, वहां पर Supreme Court can impose an order of anything on anyone as well. Okay? So, on the basis of accumulation of all these things, this particular order has been made applicable on private institutions as well, looking into the nature of the activity which they are performing over there. Okay? Now, next comes Section 19 of the Act. Okay? Section 19 of Right to Education Act talks about separate toilets for boys and girls. And the court realized this particular reality of the public education system within our country, in that in many of the institutions, there is no provision for separate toilets for girls and boys, which in itself becomes a very difficult thing for a girl child to access the same as well, right? And therefore, the court stated that toilets are not symbolic, but a functional right of a child, and absence of toilets, sanitary napkins, or disposal mechanisms is termed as a stark constitutional failure on the part of the state. ठीक है कि ये जो टॉयलेट्स का एब्सेंस है, नैपकिन्स का एब्सेंस है, डिस्पोजल मैकेनिज्म्स का जो एब्सेंस है, this is a kind of a stark constitutional failure on the part of the state. And therefore, the court provided certain set of guidelines or directions which are required to be complied by all the institutions within the period of next 3 months. अगले 3 महीने में उनको ये सारी की सारी guidelines या directions fulfill करने हैं. जैसे so the court directed compliance within 3 months for free POCSO biodegradable sanitary napkins कि ये provide कराए जाएंगे. POCSO biodegradable sanitary napkins provide करने हैं ताकि sustainability of the environment को भी आप ensure कर पाओ. Vending machines or designated school authority to provide the sanitary napkins to the girl child. ठीक है, प्रॉपर वेंडिंग मशीन होनी चाहिए या तो नैपकिन्स के लिए, ठीक है, विच शुड बी प्रेफरेबली लोकेटेड विद इन द गर्ल्स टॉयलेट ओनली, ठीक है, या एक डेजिग्नेटेड स्कूल अथॉरिटी होगी हु विल बी रिस्पॉन्सिबल फॉर द डिस्पोजल और ऑफ ऑल द सैनिटरी नैपकिन्स. देन सेफ एंड हाइजीनिक डिस्पोजल सिस्टम, covered bins and regular cleaning of those bins for the disposal of sanitary napkins, functional water supply and hand washing facilities within the toilets. Then gender segregated and disability friendly toilets should be present over there. Then menstrual hygiene management corners which will provide for spare uniforms, innerwear and disposable bags. Okay. Annual inspections will be done by the district education officers and anonymous student feedback surveys. ठीक है, ये सारी गाइडलाइंस या डायरेक्शन सुप्रीम कोर्ट ने इशू करे with respect to the menstrual hygiene. And the court also discussed about the point of destigmatization of the issue of menstrual cycle as well. ठीक है, wherein the court stated that menstruation education, ठीक है, menstruation education should be provided to both boys and girls. दोनों को प्रोवाइड करने की जरूरत है. NCERT and the state departments are now responsible to revise the curriculum, mandatory teacher sensitization, and the court's message was clear. ठीक है, that the fault is not hers. वो बच्ची की गलती नहीं है जिसके लिए आप उसको स्टिग्मेटाइज या उसको एक्सक्लूड कर रहे हो. And therefore, the judgment affirms the education, equality, dignity, and gender justice within the system as well. ठीक है, are we clear? So, but in India, implementation is very poor, even after court guidelines, like we saw in the stray dogs case. I agree. But it's a start. It's a start, है ना? From considering it as a public health issue to considering it as a right given under Article 21 of the Constitution. That in itself will change the perspective of the state authorities to look into the matter. है ना? क्योंकि अब कोर्ट ने इसको एक कॉन्स्टिट्यूशनल फंडामेंटल राइट की तरह रिकग्नाइज किया है. So that in itself will change the perspective of the authorities to look into the matter. Because now it is considered as a fundamental right of the girl child. Any kind of a violation or non-compliance of the orders of the court will in itself invite the criticism of the court as well. ठीक है? And इसलिए कोर्ट ने continuing mandamus को issue किया है, so that the court can also review the working or the compliance of the order as well. ठीक है? Are we clear with the second topic? Chalo. So let's move to the third one. And the third one which we have is the Australia social media ban for under 16s and Andhra Pradesh proposal. Okay? Now, why this particular topic came into the news? Social media and mental health. Social media and mental health is one of the most important but perhaps the least discussed topic of the 21st century. That's my personal opinion. Yes, Karthik, exactly. है ना? Social media is something, ठीक है, social media and the relationship with mental health. It is one of the most important and significant issue, but the least given importance one as well, right? And especially the impact of the social media on the minds of the younger generation. That is something which is actually going through the minds of the policy makers within our country and across the world as well. ठीक है? इसी वजह से 2024 में the government of Australia passed a particular act to ban social media for someone below the age of 16 years. ठीक है? 16 साल से कम उम्र के बच्चों के लिए उन्होंने वहां पर उस चीज के ऊपर बैन लगाया. Now the Andhra Pradesh government in our country is currently looking into the subject matter that whether they can go ahead with a similar kind of a ban or not. ठीक है? आंध्र प्रदेश की गवर्नमेंट अभी इसी चीज के ऊपर अब अपना उन्होंने एक ग्रुप ऑफ मिनिस्टर्स को कॉन्स्टिट्यूट किया है, रिस्पॉन्सिबिलिटी इंपोज करी है that you look into the subject matter, that whether a similar kind of provision can be adopted within the state of Andhra or not. And that is something which is very important. But the issue is not very simple. It is a complex issue. It includes the issue of data privacy. It includes that how will you ensure that nobody below the age of 16 years is able to defraud the system and access the social media as well. How many of you have created your first social media account by, let's say, using a fake birthday? Many of us must have done it. है ना? Many of us must have done it. On some or the other website, you must have used a fake birthday to access the particular content. How will you ensure that these kind of things will not take place? Right? So, enforcement of these kind of regulations will always remain problematic. But this is a kind of a first step which is being taken by the state of Andhra. Okay? Yes, exactly. This is the first kind of a step which is being taken by the state of Andhra Pradesh to ensure that social media. There are many workarounds. Exactly. Spotify में देखो गाने सुनने की ऐप में तक, ठीक है, an app which was basically created for listening music, उसमें तक तुम लोग अपनी फेक आइडेंटिटी, सैमसंग अकाउंट में फेक आइडेंटिटी हर जगह तो है, फेक बर्थडे हर जगह डले हुए हैं, है ना? आधे से ज्यादा तुम में से हो सकता है लोग ऐसे हो जो मुझसे बड़े हो गए हो अपने अकाउंट्स में. तो एनफोर्स कैसे किया जाएगा? दैट्स अ प्रॉब्लमैटिक इशू. बट दिस इज वन स्टेप व्हिच इज बीइंग टेकन बाय द स्टेट ऑफ आंध्रा. ठीक है? सो ऑस्ट्रेलिया बेसिकली बैंड सोशल मीडिया फॉर चिल्ड्रन अंडर द एज ऑफ 16 इयर्स. ठीक है? एंड Andhra Pradesh is now exploring a similar move, and there was a group of ministers which are constituted by the government of Andhra, which is headed by the IT and Education Minister Nara Lokesh, and objective of this particular group of ministers is to study the feasibility within the Indian legal framework of this kind of a ban. ठीक है? ऐसे बैन के इंडियन लीगल फ्रेमवर्क में क्या फिजिबिलिटी हो सकती है, इसको एक्सप्लोर करने के लिए इस ग्रुप को बनाया गया. So what did Australia exactly do? Australia basically passed an act which was named as Online Safety Amendment Social Media Minimum Age Act of 2024. ठीक है? So this act was passed by the Australian Parliament in the year 2024, but the companies were given a 1-year transition period for compliance with the requirement of the act. And the minimum age which is provided under this act is 16 years to hold social media accounts. Okay? So for any person to hold a social media account in Australia currently, it's 16 years and there is no penalty on children or parents for the violation of the act. Okay? So the liability is not being imposed upon the user of the social media. Rather, the liability or the penalty is being imposed upon the tech giants in this particular situation. So rather than making the child or the parents of the child responsible, what the law is doing is it is imposing the liability upon the company. And according to this act, the responsibility is placed on social media companies and the platforms must take reasonable steps to block under 16 users. Okay? And the failure to ensure this blockage can attract fines up to $49.5 million, which amounts to approximately 270 crore rupees. And the focus is on platform accountability and not criminalization of the users. Okay? So, what are the platforms doing? Okay? Platforms are basically utilizing artificial intelligence. ठीक है, ऑगमेंटेशन की टेक्निक्स को यहाँ पर यूटिलाइज किया जा रहा है टू आइडेंटिफाई द करेक्ट एज ऑफ अ यूजर. ठीक, बट उसके अपने कुछ फॉलोआउट्स हैं, उसके अपने डेटा प्राइवेसी के कंसर्न्स हैं. बट दिस इज व्हाट द कंपनीज आर ट्राइंग टू इंश्योर कि भाई हमसे गलती ना हो वरना हमारे ऊपर ये फाइन लग जाए. किन किन प्लेटफॉर्म्स को यहाँ पर कवर किया गया है? सो इंस्टाग्राम, फेसबुक, टिकटॉक, स्नैपचैट, रेडिट, एक्स, यूट्यूब. YouTube was initially excluded, but subsequently because of the algorithmic risk associated with the YouTube, it was also included within the ambit of the act. कुछ websites को exemption या social media platforms को exemptions दिए गए हैं, which includes messaging apps like WhatsApp, Messenger, gaming platforms like Roblox, and education tools like Google Classrooms, YouTube Kids. इनके पास exemption है. The law of the Australia is not applicable on these platforms and it has been applied on these. इस पे तो अलग से लगना चाहिए, इसके ऊपर तो मतलब मैं क्या बोलूं, इसके ऊपर तो अलग से एक बैन लग जाना चाहिए. ठीक है, बट ठीक है, इनको कवर किया गया है एंड दीज आर एग्जेम्प्टेड फ्रॉम द एप्लीकेशन ऑफ द एक्ट. क्यों किया? ऑस्ट्रेलिया की गवर्नमेंट ने, ऑस्ट्रेलियन पार्लियामेंट ने क्यों एक ऐसा लॉ पास किया? सो दिस पर्टिकुलर एक्शन बाय द ऑस्ट्रेलियन गवर्नमेंट और द पार्लियामेंट was triggered by rising teenage mental health issues. ठीक है, ठीक. So primarily it was triggered by the rising teenage mental health issues and it was influenced by Jonathan's The Anxious Generation. ठीक है, जॉनथन नाम के एक ऑथर ने एक पर्टिकुलर बुक लिखी जिसका नाम था एंग्शियस जनरेशन. ठीक है, so इस पर्टिकुलर बुक में भी बात किया गया that how the new generation is getting affected by the algorithms which are being seen on the social media platforms, by the kind of content which they are getting on the social media platform, इन सारी चीजों की वजह से. And there was a study which was conducted in 2025 and nearly 2/3 children between the age of 10 to 14 years were exposed to harmful content. And therefore Prime Minister of Australia stated that we want our kids to have a childhood rather than being क्या कहना चाहिए, traumatized because of the social media platforms. But enforcement के इशू हैं. ठीक है, enforcement के इशू हैं. enforcement के इश्यूज क्या है? एज वेरिफिकेशन आप करोगे कैसे? I'm so sorry guys. How will you verify the age of the user? So AI facial estimation, government ID uploads and third party verification. These are the three methods which are being used by the social media companies over there to identify the age of the user. But there is a privacy concern. Okay? Data risk. How will you manage the data? Data leakage. How will you ensure that? And moreover, there are easy workarounds as well. VPN usage and fake birth dates. ये तो सबसे सिंपल है. चलो वर्चुअल प्राइवेट नेटवर्क को यूज करना, VPN यूज करना, चलो मैं मान लेता हूं, is not something which will be accessible or which will be understood by every child, right? But fake birth dates, So enforcement के issues भी हैं यहाँ पर, that how will you ensure that the particular law can be enforced on the ground level as well. But this is something which was done by the by Australian government recently. अब इंडिया में क्या ट्राई करने की कोशिश की जा रही है, ठीक है. इंडिया में करंटली अगर हम बात करें, so there is a particular law which is known as Digital Personal Data Protection Act of 2023, ठीक है. And this particular act requires verifiable parental consent. तो इंडिया में माइनर्स के, बच्चों के सोशल मीडिया को यूज करने के ऊपर एब्सोल्यूट बैन नहीं है. But because if a minor is using a social media platform, you require the parental consent with respect to the data privacy of that particular minor. ठीक है. डेटा प्रोसेसिंग को लेकर आपको वहां पर पेरेंट के कंसेंट की जरूरत होती है. बट स्टिल इवन विथ रिस्पेक्ट टू दैट, टेक्निकल रूल्स हैव येट नॉट बीन नोटिफाइड बाय द सेंट्रल गवर्नमेंट. सेंट्रल गवर्नमेंट ने अभी तक टेक्निकल रूल्स रिगार्डिंग दिस पेरेंटल वेरिफिकेशन और पेरेंटल कंसेंट, दैट इज स्टिल नॉट येट बीन नोटिफाइड बाय द सेंट्रल गवर्नमेंट. अब इंटरनेट रेगुलेशन जो होता है, दैट कम्स अंडर आईटी एक्ट, इंफॉर्मेशन टेक्नोलॉजी एक्ट. ठीक है. ऑनलाइन जो भी हो रहा है, ऑनलाइन किसी भी चीज को अगर कोई भी स्टेट गवर्नमेंट भी रेगुलेट करने की कोशिश करती है ना, तो दैट इज समथिंग व्हिच फॉल्स विद इन द कैटेगरी ऑफ द यूनियन सब्जेक्ट. तो वो यूनियन का सब्जेक्ट है, यूनियन का काम है. एंड देयरफॉर एनी स्टेट लेवल बैन, ठीक है, विल रिक्वायर सेंटर्स अप्रूवल एंड पॉलिसी कोऑर्डिनेशन एज वेल. बट दिस will in itself raise questions on federalism, privacy and child's protection versus autonomy of the child as well. ये इससे रिलेटेड भी सब्जेक्ट अपने आप बनना शुरू हो जाएंगे. बट स्टिल आंध्रा इज ट्राइंग टू डू समथिंग. लेट्स से कि वो स्टेप कहां तक जाते हैं. बट व्हाट डू यू थिंक, क्या बैन हो जाना चाहिए सोशल मीडिया? डू यू थिंक सोशल मीडिया शुड बी बैन्ड फॉर चाइल्ड विद इन द एज ऑफ और बिलो द एज ऑफ 16 years? Chalo, let's move to the next topic. Now, the next topic which we have is celebrity endorsements and consumer liability. Okay? This person whom you can see in the image herein is one of the very famous actor from Kerala. Okay? इनका नाम मोहनलाल है. So, Mohanlal was basically a brand ambassador. Mohanlal was basically a brand ambassador. ठीक है. So there is particular company, Manappuram Finance, in the state of Kerala, ठीक है, which actually provides gold loans. ठीक है. मन्नापुरम फाइनेंस करके एक कंपनी है which actually provides gold loan. ठीक है. What happened in this particular case was that there was a person A, he took loan from Manappuram Finance, ठीक है, and subsequently the company charged a higher interest rate, ठीक है, as compared to something which was stated in the advertisement. ठीक है. So the manager of the company, ठीक, the manager of the company subsequently charged a higher interest rate, despite giving an earlier promise that the interest rate will be as much as stated in the advertisement of Mohanlal. ठीक है. तो ये फिर इस पर्सन को लॉस हुआ, and this individual subsequently filed a case in the consumer forum against the company and brand ambassador as well. ठीक है. Subsequently, this person filed a case. I'm so sorry. Subsequently, this person filed a case in consumer forum against the company as well as Mohanlal as well, to recover the money in this particular situation. Do you think Mohanlal should be held responsible? Do you think Mohanlal should be held responsible? That because he is the brand ambassador of the Manappuram Finance, therefore he should be held responsible for this transaction. This was the primary issue in front of the Kerala High Court. Okay? This was the primary issue in front of Kerala High Court. And the Kerala High Court simply stated that when it comes to endorsers liability, a brand ambassador cannot be held responsible for every transaction which takes place between the customer and the company unless and until there is a personal involvement of the brand ambassador in the transaction. Okay? Because even the Consumer Protection Act is not making an endorser liable unless and until it is a misleading advertisement. Okay? Misleading advertisement के लिए, the endorsers are liable within the act only for the purposes of endorsers liability within the Consumer Protection Act of 2019 is only to the extent of misleading advertisement. Okay? Only for the purposes of misleading advertisement, an endorser can be made liable. And here also, this person can be made responsible only by Central Consumer Protection Authority. Now, when it comes to the Consumer Protection Act of 2019, it nowhere makes the endorser liable for deficiency in service or product liability. Okay? The Consumer Protection Act is silent as to the endorsers of brand ambassadors' responsibility in the domain of deficiency in service and product liability. And the court stated that this absence from the act is intentional on the part of the legislature. And therefore, the court stated that endorser can be held responsible only to the extent of the misleading advertisement, not for deficiency, services or product liability, unless and until the endorser was or the brand ambassador was personally involved in the transaction. Okay? Are we clear? This was the gist of the issue and gist of the judgment which was given by the court. Okay? So let's look into the case. So this particular situation, why this case matters is it clarifies the limits of celebrity liability and endorser's responsibility under the consumer law. It distinguishes between advertising influence and transactional accountability. Okay? It is but obvious that every brand ambassador will have some or the other kind of an advertising influence. That is why they are brand ambassador of a particular institution or a company. But that does not mean that the brand ambassador or endorser can be made liable for each and every transaction which is taking place with respect to that company. Understanding? Right? And this is important for the Consumer Protection Act 2019 and misleading advertisement jurisprudence. So the primary question in this particular case in front of the court was that can a brand ambassador be held liable for unfair trade practice or deficiency of service merely because consumer relied on an advertisement featuring them. Okay? That just because of the fact that the consumer relied upon the advertisement of a person, can the brand ambassador be made responsible for deficiency in service or unfair trade practices? This was the primary question. So the facts of the case were that the borrowers initially took gold loan from Catholic Syrian Bank at 15% interest rate. Subsequently, in 2018, Mannapuram Finance took over the loan. Okay? And they stated, they promised that they will be charged lower interest rate, but later higher interest rate was demanded at the time of loan closure. Okay? What the manager told the customer in this case was that interest rate will be as much as shown in the advertisement. And the advertisement was showing Mohanlal. So the customer subsequently approached the District Consumer Commission and allegations were of deficiency of service and unfair trade practice. And relief sought over there was refund of excess interest and 25 lakh rupees compensation. And Mohanlal was impleaded solely due to the advertisement. Okay? Mohanlal was also impleaded over there due to the advertisement. अब मोहनलाल ने क्या ऑब्जेक्शन दिया कोर्ट में? So Mohanlal simply stated that he had no role in the loan transaction, interest rate determination, and dealing with the borrowers. He stated that I am a brand ambassador of Manappuram Finance. Okay? I am a brand ambassador of Manappuram Finance, but I have no role in the loan transaction, interest rate charge, okay, and dealing with the borrowers. And therefore, mere endorsement should not be considered as a service provider. I am just endorsing the product. I am not providing the service myself. So I am not a service provider within the ambit of the act. And it raised preliminary objection to the maintainability, but the district commission rejected the objection. And therefore, subsequently, he filed a case in the Kerala High Court. Okay? And the Kerala High Court stated that Mohan Lal's role was limited to appearing in advertisement only. Okay? And the complaint showed no direct assurance by Mohan Lal and no participation in the transaction. Okay? The complaint of the consumer is not showing any direct participation on the part of Mohan Lal or any direct assurance being given by Mohan Lal. So assurance basically came from the company manager, and there was no direct nexus between the endorser and the consumer's transaction. And therefore, the court stated that endorser's liability requires a clear and direct link. And therefore, mere endorsement cannot be equated with automatic liability of brand ambassador. Okay? And unfair trade practice basically comes into picture when service provider fails to deliver as advertised. And in this situation, the liability will rest on the company and not on the brand ambassador. Okay? Clear? Ari, he is a very famous star from the state of Kerala. Okay? Just like Rajni Anna of Chennai, he is as famous as Rajnikant. Okay? Are we clear till this topic? Clear, guys? Chal. So let's come to the last topic of the day, last 15 minutes, and we'll be done with this particular session. So the last topic is about the equity regulations of University Grant Commission. Okay? Chalo. So the last topic which we have is the UGC guidelines, which are basically in news recently. So in this particular part of the session, we'll be decoding the rise, fall, and the future of UGC guidelines, UGC 2026 anti-discrimination regulation. So what happened recently was on January 13, 2026, UGC notifies strict new anti-discrimination regulations to replace the 2012 framework. And then subsequently, on January 29th, the Supreme Court stays the regulation, citing sweeping consequences and social division. And current status is that 2026 regulations are put in abeyance, that is, they have been stayed. Okay? And 2012 regulations are reinstated, and a committee of jurists is to be formed to look into the regulations. Check. अब थे क्या? What are these regulations? देखो, there is an allegation of certain amount of discrimination which is being committed, or which is being exercised against the backward classes communities of our country within the educational institutions as well. And subsequently, two suicides actually shook the nation, which led or which brought this particular topic of discrimination being exercised against the backward classes on university campuses as well. And therefore, in 2012, government came up with certain set of guidelines, but because they were not enough, so the Supreme Court of India gave directions to the UGC and the central government to make guidelines which are enforceable on the grounds as well. And that was the background in which the 2026 regulations were brought into existence. So there were 2012 equity regulations, and they were being criticized as toothless and advisory. And there was a push for mandatory enforcement, which was driven by personal tragedy and judicial pressure. So what was the human cost which was involved in this particular issue? So there were tragic suicides which took place in 2016 of Rohit Vemula and in 2019 of Dr. Payal Tadvi due to alleged caste-based discrimination. And they died on the campus only. So in 2019, there was a petition which was filed in the Supreme Court, which was filed by Abida Salim Tadvi and Radhika Vemila, okay, which is Radhika Vemila was actually the mother of Rohit Vemila, and Abida Salim Tadvi was mother of Payal Tadvi, demanding robust mechanism instead of 2012 guidelines. And there was a judicial pressure on UGC as well. The Supreme Court, okay, bench of Justices Suryakant and Ujjal Bhuyan emphasized regulations must be more than symbolic. Okay. So Supreme Court also made it clear this time that they want some kind of a regulation which is more than symbolic. But UGC took it to another level. We'll discuss how. Okay. Now, what were the guidelines of the 2026 proposal? So the 2026 regulation provided a three-tiered defense with respect to caste-based discrimination on university campuses. Number one, they provided for equal opportunity center. Number two, equity committees. And number three, equity squads. So equal opportunity centers will oversee the policy and provide legal aid to the discriminated members of the university. And there were supposed to be 5 faculty members in this equal opportunity committee. And in case if there is no equal opportunity committee, the university EOC will cover for the colleges if needed. Okay. This was supposed to be at the university level. Then there was requirement of establishment of an equity committee. Now this was the decision making body within this regulation, and this was chaired by the head of the institution, and there were 10 members. Okay. So total number of members in equity committee were 10, and there was a mandatory quota, that is 5 members were to be from reserved categories, which will include OBC, SC, ST, physically disabled and women. So equity committee will have 10 members, and out of those 10 members, 5 were supposed to be from OBC, SC, ST, physically disabled and women. And equity committees were responsible for taking a decision against any grievance which is filed on the basis of discrimination within the campus. Now, there was a provision for equity squads as well. So these were mobile vigilant units which will provide for 24/7 helpline number and equity ambassadors within the campuses as well. ठीक है, अब वर्किंग क्या थी इस पूरे के पूरे प्रोविजन की? इशू यही था that 2012 वाली जो गाइडलाइंस थी, they were toothless. There was no enforcement mechanism which was present over there. So what 2026 guidelines provided was the mandatory response timeline for the equity committee. So let's say if an incident of discrimination took place within the campus and the incident is reported to the equity committee, the equity committee will meet within 24 hours of the report of the incident. Okay? The equity committee will convene a meeting within 24 hours of the report of the incident. Subsequently, within the next 15 days, they will submit a report to the head of the institution. Okay? Within 15 days, they will submit a report to the head of the institution based upon their own inquiry and investigation. And within 7 days of receipt of report of the equity committee, the head of the institution is supposed to take an action with respect to the complaint. Okay? Let's say if A was discriminated by B, so A will go to the equity committee, will report the matter. The equity committee will meet within the next 24 hours regarding the report of the incident or regarding the incident being reported. From that date, within the next 15 days, they'll prepare a report and submit it to the head of the institution. The head of the institution will take an action within the next 7 days from the date of receipt of the report regarding what kind of an action is to be taken in this particular matter. Sounds good? It appeared to be good on the face of it. Okay? Now, the primary difference between the previous regulation, that is the 2012 regulation, and 26 regulation is 2012 regulations were advisory only, but 2026 regulations were mandatory with national monitoring as well. So the institutions were supposed to mandatorily follow these regulations which were recently enacted. There was an anti-discrimination officer which was appointed under the 2012 regulations, and there is a detailed equity committee and squads which is provided within this 2026 regulation. There was no specific penalties for non-compliance, but the 2026 regulation provided for strict penalties like debarment from grants, degree programs, and online schemes as well. So if the institution was not following these 2026 guidelines now, the institutions can be barred from receiving any grant from the government or the commission. They cannot be, or they can be stopped from providing any degree courses as well. These kind of penalties were provided in 2026 regulations. But फिर प्रॉब्लम होना कहाँ से शुरू हुई? सबसे पहली प्रॉब्लम जो स्टार्ट हुई वो ही फ्रॉम द डेफिनेशन ऑफ द डिस्क्रिमिनेशन, because in this particular 2026 act, the 2012 regulations only explicitly mentioned SC/ST protection. The 2026 regulations evolved based on the feedback. Okay? So the draft of 2025 was critiqued by All India OBC Student Association for excluding OBCs from the committees. Final 2026 regulation explicitly defines caste-based discrimination to include other backward classes as well, and it mandates OBC representation within the 10-member equity committee as well. This expansion of the definition was still not problematic. Okay? This expansion of definition was still not problematic. The problem lied in the fact critiques included student groups, BJP office bearers in UP, and administrative officials, which stated that these equity guidelines were divisive and unfair, which was subsequently recognized by the Supreme Court as well. Supreme Court ने भी बाद में इस चीज को recognize किया, ये divisive हैं. एक तो harassment का fear था, that there were concerns that rules could be weaponized to harass general category students. ठीक है? Removal of safeguards, because the final regulations removed the draft provision penalizing false complaints. जो initial draft आया था regulations का, in those regulations, in that draft, there was a provision for penalization of false complaint. कि अगर आप जानबूझ के किसी के अगेंस्ट false complaint करोगे, तो आपके ऊपर action हो सकता था. That provision was removed, which led to the fear of harassment. Okay? And social division as well, because there were accusations that rigid structure create permanent caste-based silos rather than unity. So subsequently, this particular matter was challenged in the Supreme Court of India, and on January 29, 2026, the Supreme Court provided a stay, and the bench included Chief Justice of India Suryakant and Justice Joymala Bagchi. It issued notice to the Center and UGC, and 2026 rules were put in abeyance. Okay? Because they provided that, or they stated that regulations have sweeping consequences and could divide the society as well. And they simply stated that Section 31E, which is existing comprehensive definition of discrimination, तो फिर कोर्ट का कहना ये था वहां पर एक नया क्लॉज ऐड करने की क्यों जरूरत थी. ठीक है? एंड कोर्ट ने कहा कि ये जो नए क्लॉज आप ऐड कर रहे हो, दिस इज कंप्लीटली वेग एंड रिडंडेंट, and therefore the court flagged the risk that the vague language used over here is capable of misuse by mischievous elements as well. कोर्ट ने कहा हरासमेंट के जो वो एलिगेशंस है या वो जो डाउट है वो हो भी सकता है, क्योंकि आपने इतना वेगली डिफाइन किया हुआ है चीजों को. और भाई इंस्टीट्यूशन में डिस्क्रिमिनेशन सिर्फ कास्ट बेस पे ही होता है क्या? लैंग्वेज के बेसिस पे हुआ तो, रीजन के बेसिस पे हुआ तो, प्लेस ऑफ बर्थ के बेसिस पे हुआ तो, फिजिकल डिसेबिलिटी पे हुआ तो, इकोनॉमिक बैकग्राउंड पे हुआ तो, रैगिंग के बेसिस पर डिस्क्रिमिनेशन हो रहा है तो, या रैगिंग में डिस्क्रिमिनेशन किया जा रहा है तो, वो सब चीजें तो कवर नहीं हो रही थी एक्सप्लिसिटली. So therefore the court, and there was another feature of this particular regulation which was highlighted by the court, which provided for the provision of separate hostels as well. कि भाई hostels अलग अलग कर देंगे. Now imagine living in 21st century. हम भी कॉलेज में रहे, हम भी कॉलेज से निकले भाई, हम साथ में ही रहते थे. मेस में nobody used to ask that who came from where. We used to sit together and we used to eat only. अब आप ऐसी बातें कर रहे हो regulations में आकर के separate hostel कर दिए जाएंगे. And therefore the court took a note of this, and it expressed the shock at the provisions implying separate hostels or facilities. And Justice Bagchi compared the approach to pre-civil rights US segregation, कि भाई ब्लैक्स के स्कूल अलग, कलर्ड मतलब कलर्ड पॉपुलेशन का स्कूल अलग, व्हाइट लोगों का स्कूल अलग. And the court said that the unity of India must be reflected in the educational institution. And therefore, the court actually put a stay on these regulations, and the court constituted a 5-member committee of jurists to look into the particular matter. ठीक है. And court ने यहाँ पर CGI ने कहा भी that for God's sake, don't do that. We have lived in the hostel. Every community has students living together. We should move forward to develop a casteless society, rather than dividing the society in silos on the basis of caste. तो अब करेंटली कोर्ट ने क्या किया कि 2026 के रेगुलेशंस को वापस स्टे लगा दिया गया है एंड 2012 के रेगुलेशंस को वापस रीएक्टिवेट किया गया है. ठीक है. एंड द कोर्ट हैज प्रोवाइडेड दैट गवर्नमेंट मस्ट कॉन्स्टिट्यूट अ न्यू कमिटी ऑफ एमिनेंट जूरिस्ट एंड एक्सपर्ट्स which will have a mandate to review the regulations to balance protection with social unity. And the Supreme Court explicitly stated that the court should be taken into confidence and we must approve the constitution of the committee as well. कि ऐसा नहीं है कि गवर्नमेंट अपनी मर्जी से ही कमेटी बना देगी. ठीक है. गवर्नमेंट को कोर्ट को कॉन्फिडेंस में लेना पड़ेगा while making the committee, and कोर्ट के अप्रूवल के बाद ही वो कमेटी अपना काम करना शुरू करेगी. ठीक है. And there is a delicate balance which is to be made over here of providing safe spaces and social unity within the country as well. But this is what the issue of UGC 2026 guidelines were. ठीक है. क्लासलेस से कार्ल मार्क्स से याद आ गया. चलो ठीक है. So are we clear, guys? Are we clear with the topic of month of January, everyone? ठीक है. So these were the set of topics which are important from the month of January. नाउ उमर खालिद के टॉपिक को हमने अलग से कवर किया था, तो उस पर्टिकुलर सेशन को अगर नहीं देखा हो तो उसको देख लेना. यू विल गेट द टॉपिक डिटेल्स ऑफ द उमर खालिद टॉपिक फ्रॉम दैट पर्टिकुलर थिंग, एंड मोस्ट प्रोबेबली फ्रॉम द मंथ ऑफ फेब. ठीक है. इसी मंथ से या मोस्ट प्रोबेबली फ्रॉम द नेक्स्ट 15 डेज हम वीकली राउंड अप की तरफ मूव कर जाएंगे. ठीक है. जहां पर हम वीक ऑन वीक बेसिस पे टॉपिक्स को थोड़ा डिटेल में कवर करते हुए चलेंगे. ठीक. क्लियर? Clear, everyone? चलो, all right. So that's it from my side for today. ठीक है. आज के लिए इतना ही. I hope the session was clear, the topics were clear, है ना? In case if you have any doubt, any confusion, any question, so you can let us know in the comment section once the session is over. Rest, अगर session अच्छा लगा हो तो do like the session as well and do let me know in the comment section. ठीक है. चलो, all right. Thank you so much everyone. Thank you so much beta. Bye bye. Bye guys. Bye. Bye.